You sued your doctor for medical malpractice, and shortly after leaving the doctor, you obtained copies of your medical records. And you learn after your lawsuit that the doctor altered and changed your medical records. Can you now ambush the doctor at trial with your copy of your medical records to show the jury that he lied and that he altered the records to show that he did nothing wrong? You want to know the answer? Come join me on this quick walk as I share with you the answer to that question. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so here's the scenario. You sued your doctor claiming that he was careless, causing you significant harm and injury. And now, shortly after leaving the doctor's care, you obtained a copy of your medical records and then went to doctor number 2. Doctor number 2 went ahead and began treating you. But now you held on to a copy of those records. And now you went to an attorney who evaluated your case and had it reviewed by a medical expert who did in fact confirm that there was clear violations from the standard of care causing you significant harm and injury. And it was based upon those original records that the doctor whom your attorney consulted with felt that there was a valid basis for a case. Okay, so now during the course of your lawsuit, your lawyer asked the defense lawyer, the attorney who represents the doctor whom you have sued, for a copy of his own records. And a short while later, the lawyer for the doctor goes ahead and sends your attorney a copy of the doctor's records, your records. And as he's going through page by page, he comes to the significant conclusion that, you know what? These records are different. The records that you had, that you brought with you to doctor number 2, and the records that your attorney's expert reviewed are in fact significantly different than the records that the doctor's lawyer provided to your lawyer. And now you've got some Blockbuster evidence. You've got something that clearly shows the doctor altered his medical records. We're not talking about just leaving out some records. We're talking about materially changing records to show that something was done wrong or to show that he did nothing wrong. And guess what? Can you use that information later on at trial to ambush the doctor without disclosing that information to the defense? The answer is, in all likelihood, no, you can't do that. You want to know why? It's because if you try and ambush the doctor is going to scream bloody murder. His attorney is going to scream bloody murder. And why is that a big deal? It's because his attorney is going to argue that he never had a chance to see these records. And because of that, he's going to argue that he's significantly prejudiced and did not have an opportunity to view these records first and to prepare a proper defense for these particular records. How cool would it be if we are able to show at trial that this doctor, your doctor, not only altered the records, but did so to try and show that he did nothing wrong in your case, when in fact his original records clearly show that he did? That would be awesome, and I think the jury would actually wind up hating the doctor because, why? Because now he's trying to hide the fact of what he did. And that could have devastating consequences for the doctor with this particular jury. And in addition, the judge might refer him to the district attorney for doing what? For doing something illegal, for physically altering your records to show something totally different than what actually occurred. If we do not disclose these records, these altered records, to the defense during the course of this litigation, the defense will have a valid argument to say, listen, Judge, Mr. Oginski and his client never disclosed this information to us. We are at a significant disadvantage. We had no idea. I don't know whether these records are valid or not. The doctor was never questioned about them during his deposition, his question and answer session, and they have these records from the very beginning of this case. How could they not disclose this? Now that's an unfair advantage that he's gaining, and we don't even know if these records are actually the doctor's or anything about them. We don't know where they came from. We don't know who got them. We don't know whose handwriting they are. And now it raises all sorts of issues. And now we get into a whole legal problem about whether or not these records are actually authentic. We don't want to be in that situation in the middle of trial having to deal with this legal issue. So what should we do? The proper thing to do is, once we learn that there are clear discrepancies between the records that the doctor provided to you as well as the ones that his attorney provided to us, now the best thing to do at the appropriate time is to disclose that information to the defense. And you know something else? Doing that might actually prompt them to try and settle this case, because they're quickly going to realize that there's no way they can defend the case, assuming, of course, these records are authentic, assuming that these are, in fact, the doctor's records, and that what the patient said did, in fact, make sense, that she got them immediately after leaving the doctor's office and now went to doctor number 2, and doctor number 2 has a copy of these records. So, assuming all of those things to be true, guess what? The defense, when they go through these records, will recognize that, hey, the doctor did something wrong. He never should have done this. And even if his medical care and treatment was defensible, now, because of this whole issue about the doctor altering your medical records, now it might mean that the case is no longer defensible. So why do I share this quick information with you? I share it with you because I'm on a beautiful walk today, and I thought you'd find this interesting in these medical malpractice cases and how they actually work. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.